The Australian legal system. This is Australia. The nation of Australia is divided up into 6 states and 2 territories. The 6 states are Queensland, New South Wales, Victoria, Tasmania, South Australia, and Western Australia. The 2 mainland territories are the Northern Territory and the Australian Capital Territory, where the national capital, Canberra, is located. Australia is a monarchy. The head of state is presently Queen Elizabeth II. Queen Elizabeth II is also the Queen of many other countries around the world, and the Queen of Australia therefore does not actually reside in Australia. Instead, she has appointed someone to be her representative, someone who remains in Australia and carries out the Queen's responsibilities. This person is known as the Governor-General. Similarly, within each of the 6 states, the Queen has appointed a representative to act on her behalf and exercise her responsibilities in her absence. This person is known as the Governor. Australia therefore has 1 head of state, the Queen, 1 Governor-General, and 6 governors. None of these people actually exercise significant political power. The nation's political leader is the Prime Minister. Within each of the 6 states, the political leader is the Premier. Australia therefore has 1 head of state, a Queen, 1 Governor-General, 6 governors, 1 Prime Minister, 6 Premiers, none of whom actually make law. The 2 main sources of law, as we learned earlier, are Parliament and the courts. Australia has 1 national parliament located in Canberra, and each of the 6 states has its own parliament. Similarly, there is a national court system, including the High Court of Australia, located in Canberra, and each state has its own court system. Australia, therefore, has 1 head of state, a Queen, 1 Governor-General, 6 governors, 1 Prime Minister, 6 premiers, 1 national parliament, 6 state parliaments, 1 national court system, and 6 state court systems. It's therefore no wonder why many Australians are utterly confused by their legal system. Why does a country that is relatively small in terms of population have such a complex legal system? The answer, of course, lies in the history of that legal system. So let's take a few minutes to consider the history of Australia's legal system. If we're going to go right back to the beginning, then we should appropriately acknowledge the existence for tens of thousands of years of a sophisticated and effective legal system, the Indigenous Australian legal system. The Indigenous Australian legal system served all the purposes of law that we considered in the earlier topic. It maintained social order. It was a system for resolving disputes. It restrained the abuse of power. Unfortunately, when the British arrived in the 1700s, they did not recognize the Indigenous legal system as a legitimate legal system. Instead, the legal position taken upon British settlement was that Australia was empty when the British arrived. There was no one living here. Australia was formally declared to be terra nullius, a Latin term that means empty land or land belonging to no one. Incidentally, in the 1980s, in the famous Mabo case, the High Court of Australia famously overturned that categorisation of Australia as terra nullius and finally acknowledged the existence of the Indigenous legal system prior to British settlement, as well as the possibility of a continuation of Indigenous property interests until today. This was the origin of the concept known as native title. Nevertheless, when the British arrived, Australia was declared to be terra nullius, and Australia was therefore seen as having been settled by the British rather than conquered by the British. This is an important distinction under international law at the time. If Britain conquered a new territory, in other words, it acknowledged that there were people living there beforehand, and Britain had to essentially fight its way in order to take control, the legal system of the conquered people stayed in place, and the British simply took over and changed the laws to suit them. But when a new territory was declared to be empty, and therefore settled by the British rather than conquered, there could be no pre-existing law within that territory, and the British therefore brought British law with them, so that when new legal problems and legal disputes arose in the new territory, they were settled according to British law. This is known as the doctrine of reception, and this is why the foundations of today's Australian law is British law and not Indigenous law. It's important to note that Australia did not begin as a single nation. Rather, it began as a group of independent colonies. The first colony was New South Wales, followed by colonies in Queensland, Victoria, Tasmania, South Australia, and Western Australia. Each of these colonies was initially closely controlled by the British government, which was represented in the colony by a governor. As time passed, however, each of the colonies became increasingly independent from Britain and increasingly sophisticated in terms of the elements of each legal system. Each colony was permitted to have its own constitution, the document that set out how the colony's legal system was to work. And each colony was eventually set up using a similar model. Strictly speaking, the head of state for each colony was, of course, the King or Queen of England at the time. That person was represented in the colony by a governor. Initially, that governor exercised almost absolute power within the colony, but as time passed and the colonial legal system evolved, power was distributed. Each colony was allowed to set up its own parliament to make law. Each colony was allowed to set up its own court system in order to resolve legal disputes. And, eventually, each colony adopted a system based upon the British system where members of the colonial parliament were selected to act as advisors or ministers to the governor, including one minister who was senior to the others, known as the Premier. Each colony existed as an independent legal system within Australia. This created problems. Each colony's laws were initially based upon British law, but as time passed, each colony began to adapt British law to suit its own circumstances, and not necessarily in a manner consistent with what was happening in the other colonies. In other words, the laws of each colony diverged from the laws of the other colonies. This made trade between the colonies particularly difficult. As time passed, more and more people called for the colonies to unite, to form a single nation in order to pool its resources, but also to seek to achieve a greater level of consistency and uniformity between the colonial laws. Eventually, after many meetings, conferences, and negotiations between the colonial governments, agreement was reached. The 6 colonies would unite to form a single nation. The Commonwealth of Australia came into existence on the 1st of January 1901. It is very important to note that the 6 colonies were not replaced by a single nation with a single national government. The colonies and their legal systems were retained. They continued to exist in the form of the states. Each colonial parliament became a state parliament. Each colonial court system became a state court system. Each colonial governor became a state governor, and so on. The 6 colonial governments remained in place, but a new 7th government, a federal or national government, was created to regulate national matters. And this new federal or national government was again set up using a system adopted from Britain and very consistent with the legal systems that existed within the colonies. The head of state was the King or Queen of England, represented within the federal or national government by a Governor-General, called such in order to distinguish this person from the state or colonial governors. A new national or federal parliament was established, a new national or federal court system was created, and again, adopting the system that originated in Britain, the executive government was made up of people selected from the parliament to act as ministers to advise the Governor-General, including one minister who was senior to the others, called this time the Prime Minister. We will, in the next topic, explore these particular roles played by each element of the government and how the federal government relates to and works with the state governments. The history of Australia's legal system has been a story of increasing independence from Britain. Since British settlement 200 years ago, governments in Australia have acquired increasing freedom from interference by the British Parliament. Today, it is no longer possible for the British Parliament to make laws that bind or regulate Australia. Australia is effectively an independent nation. There does, however, remain one important connection back to Britain. The Australian head of state is automatically, under the Australian Constitution, the British head of state. We still share the Queen. This has led many people in Australia in recent years to ask whether the next and final step in the journey of independence from Britain should be taken. Should the Queen be replaced by an Australian head of state? Should we replace the Queen with a president? In order to do this, it would be necessary to amend the Australian Constitution. An important step in this process is the holding of a referendum. Such a referendum was held in 1999. The Australian public was asked whether or not Australia should become a republic and replace the Queen with an Australian head of state. At the time, the decision was no. But this is an issue that is unlikely to go away, and Australia may face another referendum in the near future and be asked once again whether it was time to take the final step.